to help us have a conversation about the historical and political as well as legal relevance of the Chinese Exclusion Act, I am pleased to be joined up here by our very own Dean David Lopez, as well as Professor Sahar Aziz. So if you could please help me in welcoming both of them up here. Okay, so why don't I'll begin. We will each talk for about 5 minutes, and I will speak first, and then Dean David Lopez, and then Professor Aziz. So the film, let me actually come up here because I have a PowerPoint to help us situate the conversation. The film asks us to, it raises a number of different questions that perhaps during the Q&A we can discuss. The roles that race, gender, class, and religious beliefs, and what roles they played in the passage of the Chinese Exclusion Act. How did the presence of or lack of Chinese immigrants within a particular state, how did that lead to the act itself? And then what are your observations about the political cartoons that were distributed during that time? Before I continue, I want to thank our co-sponsors. As you know, this was directed by Rick Burns and Lin Chu, and it was there by Sequel Films and the Center for Asian American Media. In fact, here at Rutgers, we have a new professor, Jack Chen, who was a founder, or one of the founding members of the Center for Asian American Media, and so his work is a big part of why this documentary was started. But I wish to thank APALSA, Professor Suzanne Kim, and the Center for Gender and Sexuality, Law and Policy, and of course Professor Sahar Aziz and her own Center for Security, Race, and Rights. Thank you also to Chancellor Nancy Cantor for providing us a seed grant to begin this center, and to Dean David Lopez for his support. So I wanted to link up the Chinese Exclusion Act to a case called the Che Chang-ping versus United States, which is known as the Chinese exclusion case. Those of you who watched the Judge Kavanaugh's hearing might remember that Senator Kamala Harris asked him what he thought about the Chinese exclusion case, and she was referring to Che Chang-ping. And the reason why I wanted to talk about Che Chang-ping is because this was the case that upheld the Chinese Exclusion Act. We don't have a lot of time now to go over everything, the facts issue rule, so I would just briefly summarize some of the key points to keep in mind about this case, which then relates to Trump versus Hawaii. Okay, so this case allowed the United States Supreme Court to essentially rule where the power to exclude non-citizens come from. The holding explained the basis of the power of exclusion. It also, the opinion itself, talked about the relationship between exclusion on the basis of race and national security. And then the opinion also highlighted what the court thought of was the limited role of the judiciary in immigration issues. So here are just some key quotes from the case. First, the court talks about the power of the government to exclude foreigners has been asserted and never denied by the executive or legislative departments. In that brief quote, the court is essentially saying that there is this power that rises. It arises from international law. It arises from sovereignty that allows a government to exclude non-citizens from their own borders. And then second, in the second quote, where the court says to preserve its independence and give security against foreign aggression and encroachment, the court says that's a part of the power of Congress that is needed in order to exclude non-citizens. That is, in order to preserve security of the United States, to preserve independence, Congress must be equipped with the power to exclude non-citizens. There was a challenge, of course, to the Chinese Exclusion Act, and that it excluded people on the basis of race. Right? There was Che Chang-ping was a person who was a legal resident of the United States. He left the United States based on a promise that he would be able to come back. So he had what's called a certificate This is what he had right before he left the United States, and he was promised that this would be his entry back. But when he entered, when he tried to come back to the United States, all licenses had been revoked under the Chinese Exclusion Act. And so he argued that the Congress did not have the power to exclude him. But we already know that the U.S. Supreme Court said in this case that because of sovereignty, because of independence, non-citizens may be excluded. And also the presence of foreigners of a different race, according to the court, who will not assimilate with us, who are dangerous to its peace and security, may be excluded. And so lastly, the court then says these are not questions for the judiciary, not questions for us. The question about exclusion of non-citizens belongs in the political departments, Congress, and the president. So let's think about these four themes, right? About the U.S. Supreme Court then taking a step back, allowing the political departments to pass laws regarding the exclusions of non-citizens in order to promote national security, in order to promote independence. And so I leave you with these thoughts as we then move on to talking just more in general about the political and contemporary relevance of this case. Dean Lopez?
Thank you. First of all, how many of you have some familiarity with the story, with the Chinese Exclusion Act? Okay, that's good. That's good. The reason I ask is because I think a term that we use a lot these days, talking about sort of political views or social views, is the term bubble, right? So I'm always thinking in terms of bubbles, and we all live in our bubbles, right? Some of us have narrow bubbles, and some of us have large bubbles. And when we talk about issues like this, and I think this was sort of alluded to in the film, when it was talking about some of the political support for this, for the Chinese Exclusion Act from parts of the country where there were no Chinese, that I always think in terms of bubbles, in terms of the ability of the elected representatives to actually have a little bit of creative empathy to walk in someone else's shoes, to use the terms of Atticus Finch that we're all familiar with, to walk in someone else's shoes. But politicians will be politicians, and it sort of explain the political, dynamics of the time, and there's no justification for that, of course, but it is sort of an explanatory explanation. But what's sort of curious to me is sort of the judicial response. So this was a unanimous decision, right? This was a unanimous decision. This was a 9-0 decision. And it came, it came close in time to Plessy v. Ferguson, which was a 7-1 decision, and the dissenter in that case was the great Justice Harlan. But Justice Harlan was with the majority here, also, right? And when you look at these decisions, I guess the question I always ask with respect to the judges is, what was their world like? What was their background? What opportunity did they have to be able to creatively empathize with the experiences and to understand the impact of the decisions on others, right? Because now, of course, if we talk about, all they were doing in Plessy v. Ferguson is calling balls and strikes, that sounds ridiculous, right? I mean, that's sort of the term they use in the judicial hearing. Oh, judges just call balls and strikes. No, these decisions have like a moral resonance, and the decisions are defined and they're determined to a certain extent by the backgrounds of the judges and by their ability to recognize their bubble and perhaps transcend the bubble, right? And so I'm always thinking about that. I'm always thinking about that particular bubble. I'm thinking about the educational bubble in terms of how much this is taught in the schools in the United States, how much we know about this in our history classes. I think in terms of geographic bubbles. I'm a Westerner, so this is part of the history of the West. The involvement of the Chinese community in the construction of the West is a big part of the story of the West, right? The railroads, the cities, all of that, is a story of Asian and Latino labor in terms of the construction. But then you wonder, do we learn that in our schools, right? Is that part of the history that we learn in our schools? and what kind of educational bubble do we live in, and how do we sort of rise above the bubble. And the last bubble I want to flag, and this sort of goes back to the Kavanaugh clip, which I circulated yesterday, and I just encourage all of you to look at it, because it's very interesting, right? You know, and we all understand the confirmation, there's a confirmation belly that goes on where you don't want to say anything. I mean, everyone, you know, in my lifetime, or since Robert Bork, you know, the nominees are sort of trained. I'm a former political appointee, so I went through this training too. Like, just answer the question that you want to answer, don't answer the question that's asked, right? And so you kind of see that like dance back and forth between, you know, Kavanaugh and Harris when it asked about this case that virtually every judicial scholar now thinks, you know, is morally repugnant, right? And it's never been reversed because it was based very explicitly on racial classification. And it has a moral resonance. And, you know, we kind of look back and sort of say, you know, we don't say, oh, the judges were just calling balls and strikes. I mean, we look back and say the judges went off the rails, probably because they didn't have the worldview to understand the implications of this type of overt racial sort of subordination. But one of the things that Kavanaugh says that I thought was very interesting, and it's in the clip, he does say, oh, well, that was in the era of Plessy v. Ferguson, right? And of course, you know, sort of the implication is we were asked backwards back then, but we know much better than that now. Which brings me to the last bubble, which is a bubble of what I will call presentism. The sort of notion that presently we're more enlightened and that we're more, you know, we're more morally lucid about these types of issues, and that back then, you know, they were kind of ass backward racist, right? And we can sort of go tisk, Plessy v. Ferguson, tisk, Chinese Exclusion Act cases, tisk, in all of these areas. And then sort of say, well, we're now in this place where we're able to just call balls and strikes as judges. We're just calling balls and strikes. We're not legislating, we're not doing anything. But I think the presentism is sort of the most dangerous bubble. And it's a dangerous bubble if you are from an educational bubble where you don't learn about this. It's a dangerous bubble if you're from a bubble where, you know, you haven't had the opportunity to be around people and sort of understand the narratives and the experiences of other people. Because it's a bubble that is very delusional that what you're doing is based on some sort of normatively neutral principles, yet you run into the problem of how is history going to judge us 100 years from now. And I will tell you the judges who wrote Plessy v. Ferguson and the judges on this panel are not regarded by legal scholars very highly. The judge that is regarded highly is Justice Harlan, who did the dissent in Plessy v. Ferguson, and sort of belied the notion that there was only one way to think about these racial issues at the time. And I just, you know, as we think about this, I encourage you to really think about where we are in society. And we see, you know, and I know that there are a lot of, you know, it's a fraught era of a lot of morally challenging issues, the top of which, you know, it may be the issue of immigration. But, you know, I really, you know, encourage all of us to kind of think outside of our presentist bubble and see if we can find a way to address these issues in a way that allows us to walk in the shoes.
Yeah. Thank you so much, Professor Rosor and Dean Lopez, for inviting me to participate in this panel. We're very, very fortunate to have Professor Rosor here as one of our newest professors and also as the founding director of the Center for Immigration Law and Policy. So I'm going to start with a tisk. I like that. Tisk. In May 2017, quote, on a website, it was stated, Donald J. Trump is calling for a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on. In March 2016, he expressed his belief that, quote, Islam hates us. We can't allow people coming into this country who have this hatred of the United States and of people that are not Muslim. That same month, Trump asserted that we're having problems with the Muslims and we're having problems with Muslims coming into the country. He therefore called for surveillance of mosques in the United States, blaming terrorist attacks on Muslims' lack of, surprise, surprise, lack of assimilation. I think I've heard that term before. And their commitment to Sharia law, which he doesn't know what that means. A day later, he opined that Muslims do not respect us at all and don't respect a lot of the things that are happening throughout not only our country, but they don't respect other things. So that didn't happen a century ago, right? That happened a year ago, May 2017, 3 months after he took the oath of the presidency. However, Justice Roberts, in his majority opinion in Hawaii v. Trump, said, you can't hold accountable a president for the statements he makes before he takes the oath of office. Because once he takes the oath of office, now I'm ad-libbing, he transforms into this superhuman who no longer, who puts all of his past behind, and whatever he said is irrelevant to his belief system, and he's just transformed into this new human being. So first is, do you agree with that based on what you instinctively know about human nature? And second, the facts don't support his assertion, Justice Roberts' assertion, that all of the anti-Muslim Islamophobic statements were made before he became president. There are actually many more. And I'll put a little plug in for my article called A Muslim Registry, the precursor to internment, ? And I have a list of all of the statements that Trump made. So that is kind of how I want to start the discussion about Hawaii v. Trump and connecting the dots between something that happened in the late 1800s and then continued on and frankly didn't really get removed to what, 1942?
52.
52 was when the Chinese Exclusion Act, the statute, right, was repealed, and then it wasn't until 1965 that Asians were able to immigrate and in more than de minimis numbers. So this is a very recent history. So when we're doing these comparisons, and I could go into a whole separate discussion about the opinion, but look at Justice Sotomayor's dissent and compare it to Justice Roberts, and you're going to see the complete different jurisprudence. And it represents also, I think, the polarization even among the public, where somebody sees a sky and someone says it's blue and someone says it's green. And as far as I'm concerned, it's blue. So I see Justice Sotomayor's opinion or dissent, and it totally makes sense. But because essentially what she implies in there and what Justice Roberts' majority refused to accept is that these underlying stereotypes have always existed against people who are considered foreign or considered the enemy in the particular context. And if you look at history, you'll see the same stereotypes used. So here when we watched, they were talking about women being prostitutes, men being cheap labor, there's all these stereotypes of Chinese and Asians being sneaky and secretive and having these foreign cultures being uncivilized, as compared to the norm of white, Protestant, Northern, Western European standard, which is false on a contemporary basis. That is no longer what represents America factually, even if it may have been the majority more than 200 years ago. And then you compare that to Arabs, Muslims, South Asians, which get homogenized into one racialized group. So you have the harem and the exotic woman, the belly dancer, and so there's a lot of this hypersexualization of women, but then at the same time they're oppressed by their misogynistic men who are backward, despotic, violent, terroristic, bloodthirsty. And the themes are uncivilized, failure to assimilate, enemy of the state, and permanently foreign. So we see a lot of these very similar stereotypes. So be aware when you hear those catch terms and ask yourself, why are we still using these same terms in the contemporary era? The other thing that's fascinating, and I think this applies perhaps to a larger extent to in the immigrant rights debate, which implicitly in parentheses the subtext is Mexican, right, or Central American, which is the pitting of new immigrants who, for various reasons, tend to disproportionately represent low-income wage earners, and pitting them against, quote-unquote, Americans who are also low-wage income earners at the lower scale, and having the elites exploit those divisions and profit from those divisions. Even though, in fact, if you looked at their material interests, they have a lot more in common in terms of class, the new immigrants and those who are third or fourth generation. And I'll let Dean Lopez and Professor Villasur want to talk more about that. But that's a really fascinating dynamic that many of us are not taught in school, which is we're taught, oh yes, race and there's racism, but there is a class component to that, and there's this repeat of history where you have wealthy playing off and benefiting financially and politically by the divisions among different minority races, particularly in the lower wage arenas. And what are we going to do about that? What are you going to do about that as a lawyer? So I guess I will end, and I'm happy to talk about the doctrine and the minutia of the cases with questions. But I'll just end by saying that I agree with my co-panelists. We are not even close to being out of the woods when it comes to race issues. We are not post-racial. And I think now the evidence is pretty clear, but 15 years ago that was considered a controversial statement, especially after Obama was elected, or I should say 10 years ago. But we are not post-racial. And so the question is not does race matter, because it does, but the question is how is it going to matter and how are you going to decide it's going to matter in a way that preserves what we're all here to do, which is support and defend the rule of law, democracy, equal opportunity, and all the values that create American exceptionalism, or our vision of American exceptionalism, but we are not an exception. Like, we're just like any other country. We're just like we have hierarchies like any other countries. We have isms like every other country. And so the problem I think that we have in our education system is not anti-Americanism, that the liberals are anti-American, these professors who are trying to brainwash you and they're anti-American. That's not the problem. The problem is American exceptionalism. We have to stop believing that we're special and we're an exception and start accepting and being humble that we're like every other people all over the world, like every other country, with a unique history, and then try to aspire to be exceptional. We may never reach it, but we are not, in fact, exceptional. And as long as we keep thinking that, we're just going to keep continuing, repeating the mistakes of history to the detriment, I think, of our people and our country. Thank you.
Thank you. So we have a few minutes for questions and comments from the audience. Yes.
I mean, there's clearly parallels to be drawn between what happened in the late 1800s and what's happening now. So what is it that we're doing wrong as a people or as a community that we're still kind of stuck in the same rut? And would you say there's the greatest onus on Asian American communities because we've kind of been there, done that, when it comes to looking at our Latino, Latinx communities and how we should be, I guess, stepping up more to the plate because they're in a state of vulnerability when it comes to undocumented people?
I think that Asian Americans should rise up, but so should everybody else. Latinx, Muslim Americans, white Americans, African Americans. This is an issue that the executive order, the Chinese Exclusion Act affected everybody, right? And just as in the Chinese Exclusion Act, that era, where there were people who were protesting and who were fighting against those exclusions, so too should we continue to do that today. We cannot sit back, despite what the U.S. Supreme Court has said in 1889 or in 2018, that these exclusions are constitutional. Despite what they're saying, there are other ways of critiquing and questioning. And maybe this is when the political process comes in. Law might have been limited in Trump versus Hawaii, and it was limited in the Che Chang-ping case. But then there are other avenues for social change, social and political change. Yes?
I was wondering if you could address the dichotomy with when they did the decree on the current Muslim ban, but at the same time they commemorated and finally struck down the internment camps law, and how they could in one hand say okay, well, the government overstepped by excluding a whole race on national security grounds, but on the same hand, we're going to reaffirm that they're allowed to do that. How is there even a legal ability to do both things simultaneously?
Great question. So one explanation, at least for the Kuromatsu portion, which was a small portion of the opinion, was that Roberts put to rest what a lot of legal scholars had already concluded. We had a bit of a debate. Is Kuromatsu still good law? Is it not good law? Has it effectively been overturned? And I think it was a very easy win for him to come out and say, hey, I'm the good guy here because I'm going to do it. I'm going to clarify the water. I'm going to clarify the landscape and say, yeah, Kuromatsu is bad law, and we are officially, as the Supreme Court, overturning it, right? Because it had never actually gone up to the Supreme Court to be overturned. So I think that is a positive effect, but I think it's a ploy. I can't put my shoes in the position in Justice Roberts' shoes, but I suspect the argument would go along the lines of these are two completely different scenarios. Right? Interning over 250,000 people, many of whom were American citizens, right? Not just immigrants or not just, I don't know if, many were American citizens, because at that time, Asians could not naturalize. It was illegal. You could not naturalize. So even if you were legally here, you could maybe be on a green card or some other legal status, but you couldn't become a citizen at the time. So they were the Japanese Americans who were born in America. And so he'll say that's completely different. What we're talking about here is, there's only 5 or 6 countries. It doesn't include everybody. We've got exceptions for permanent residents. We've got exceptions for people who have already been granted asylum. In Iran, for example, I think student visas and some visitor exchange visas are not included. We took off Iraq. We took off Chad. So he is effectively taking the position of the Trump administration, which was a huge backtrack after many of you, I assume, were part of the streets. I mean, I was at the Dallas-Fort Worth airport, and I took my children there. And I said, you see, you have a lot of work to do when you grow up. And we're not done. Because imagine you've got a parent that's on the way, and they have a visa, and suddenly they're going to get to the airport and be turned away. And some of them were older and elderly and children. It was havoc. So, Trump, the good news is that the public opinion and public advocacy mobilization disciplined Trump temporarily and forced his administration to go and jump through the hoops and pretend like this was actually not based on unlawful animus and narrow the impact. But it didn't change what Sotomayor said, the rotten foundation on which these executive orders were found. And so he effectively used, and I'll let Professor Villazor and Lopez talk about the plenary power in immigration law. Right? But I will tell you, this case was in many ways a nightmare for anyone who represents individuals in immigration law and national security, because it was the intersection of the two areas of law where the executive authority has the broadest discretion. And it's the two most difficult areas of law to win when you're trying to challenge executive authority. And so the plaintiffs were walking in at a disadvantage, from a legal perspective.
Dean Lopez, do you want to say a few words? I know he's very busy, and I'm happy that he's here. He has another meeting coming up.
I know this is a conversation that could probably go on for a long time, so I really, apologize for having to step out, and I'm going to go meet with our clinical faculty and talk about some of the good work that they're doing. I think this is an area, in terms of what Justice Roberts did, it kind of reminds me of sort of the analogy to the use of Justice Harlan's colorblind language in subsequent decisions, that there's sort of a surface appeal of sort of a neutral principle of law that sort of masks over what was happening here, and that was that you had executive orders that at the inception were based on these sort of good old-fashioned racialized stereotypes. And so it's always good to kind of watch this maneuver in terms of you know, it's like on one hand, Korematsu, hooray, Korematsu's reversed. Everyone knows that was a moral abomination. Maybe at the time they would have said the judges were just calling balls and strikes, right? That's all judges do, they just call balls and strikes. But, you know, I think the fact that that happened sort of simultaneously with what I view as coming out of the employment law civil rights bill is sort of an exclusion of evidence of animus, I thought was kind of a very interesting move. And I think in terms of like the politics of the situation, I think what we've seen is that you see the same dynamic generation after generation after generation, right? You see the same dynamic. You see the issues of labor, and you see the division between the groups, but the particular group changes. And there's a famous book called How the Irish Became White, wonderful book, and it talked about the experience of the Irish in the United States and sort of the racialized experience of the Irish in the United States, but how there's sort of this assimilation movement, and then you talk now about Chinese Americans, and you see these sort of stereotypes, and you see that, like, you know, in the biggest movie in America is what's it called? Crazy Rich Asians, right? You see that sort of like existing side by side. But I think the point of these exercises is to understand that the dynamic happens over and over and over again. And at this moment, you know, the immigration debate is very much Hispanicized or Latinicized, and then the national security issue, you know, becomes about the Muslims. But again, the same, you know, the sort of the sexualization of some of the issues, the whole issue of they're ultimately unassimilable. You see the same tropes, you see the same dynamics over and over again, even though it may be different individuals who are part of it.
Thank you. We are actually out of time. I know some people have a class at 1:05, including my students who are here. So you're excused from being late to class today. I just wanted to close by responding to a question earlier. Why do certain things keep happening again and again? Scholars refer to it as historical amnesia. We forget each time, right? The things that happen. You heard the same themes. You saw the same images of exclusion, of people who are not assimilable, people who are foreigners and that they cannot be trusted. Think of how often you hear that about immigrants today. Think of words that are spoken by politicians to describe people from Mexico or people from Haiti and the other African countries. It's important to think of how the comments and events of today relate to the past, right? And ensure that we are mindful of them and do something about them legally, politically, socially, and culturally. And so on behalf of the Center for Immigration Law, Policy, and Justice, I thank you all for being here today. I would also be remiss if I didn't thank Habiba Johnson and Tanya Bentley, the program coordinators, and Wei Fang, and the IT department for making live stream happen. I think it's happening. And for bringing the food here. And thank you, all of you, for packing the room. And I hope to see you again at the other center events. Thanks. I will be here to answer any individual questions that you might have.
I think she's like in
Can I have a sign-in sheet, please? Oh, okay, great. Thank you. Please sign in.